Okay, hi everybody. Welcome back to our fourth and final session on enforcement perspectives in reforming data protection law. We have four speakers who will hopefully be shining some light on these questions. We have Johnny Rand from the Irish Council for Civil Liberties. We have Luca Tosoni from the Norwegian Data Protection Authority. We have Orla Lynskey from the London School of Economics. And we have Gloria Gonzalez Fuster from, I'm going to pronounce this wrong, Vrije, Universiteit, Brussel? Yes. Okay, fantastic. Great. I think our first speaker is going to be Orla. He's going to set the scene for us. And that will be on, still deficient by design. There you go.
Thanks, Jennifer. For my couple of minutes today, what I'm going to do is to give you a very kind of broad overview of some of the issues that you start to encounter with the transnational enforcement of the GDPR. And so this is very loosely based on two papers. So one co-authored paper with Giulia Gentile on deficient by design, hence the still deficient by design, because that was published a couple of years ago, and a current legal problems paper on some of the problems maybe following from the last session that you see downstream when you seek or strive for complete and effective data protection. So that is something that, in principle, I am not opposed to at all, but I think that a lot of the challenges that you then start to encounter kind of downstream when it comes to enforcement, and this maybe requires some modulation of enforcement strategies. So in trying to synthesize a little bit the debate over the past few years about GDPR enforcement, I think that there are kind of two key sets of problems that we encounter. So the first set of problems relate to the type of decision making that the GDPR foresees, the type of enforcement model that the GDPR foresees. So this is in EU law termed a composite administrative procedure. And by that, we just mean that we have a set of administrative procedures that entail both cooperation at national level between national authorities. So the GDPR, as you probably know, requires cooperation between national data protection authorities, but also when there are problems with that cooperation between national data protection authorities, then this takes on a kind of a vertical dimension because an EU body is involved, the European Data Protection Board. So we're talking about enforcement cooperation and enforcement work across a number of different axes. And this kind of raises its own very distinct set of enforcement problems that I would say are not unique to data protection law, but are rather things that you see across EU law more generally. The second problem is something that was already touched upon, I think, in the session this morning about UK data protection enforcement and some of the challenges there. And that is a kind of a lack of consensus about what we would consider to be effective enforcement. So what is the benchmark that we could think about for effective enforcement? So just going into a little bit more detail on both of those. As I said, you have these very kind of complex administrative constellations when it comes to enforcement of EU data protection law. So this has been called by the administrative lawyer Herwig Hoffman a diagonal multi-jurisdictional composite procedure. So even the name is kind of slightly off-putting. But it is kind of recognized in other fields of law that in creating these kinds of complex procedural constructs, he, a human rights lawyer by training, says that this kind of shows a lack of awareness on the part of the legislature about the protection of individual rights and supervisory necessities. So it's already recognized that once you start to enforce the law in this way, that we're going to have problems for the enforcement of individual rights and remedies. And in the paper with Giulia, we started to kind of map problems that were already evident from existing literature, including a study on the part of Access Now around the rights of complainants and the work of many others. And I think you could see that at EU level, some of the issues that you faced with the European Data Protection Board's systems was a lack of clarity about certain key terminology, like what is a draft decision in this system, or what do we mean by without delay, which could be interpreted in incredibly different ways. But also at national level, complainants have been realising that when they lodge a complaint in one jurisdiction, that their rights and entitlements in that jurisdiction might not necessarily be recognised or replicated in other European jurisdictions. And so I'm sure Johnny and others will discuss this with far more kind of colourful details, but you could think of issues here around the standing of civil society organisations. So the Norwegian Consumer Council had some issues with the Irish regulator having been recognised, so you might hear the Irish regulator a bit, recognised as having standing in Norway but not in Ireland. Issues around the right to be heard. So the exclusion of complainants from procedures where it was their complaint that initiated a procedure, but that data protection authorities reinterpreted this as a kind of an ab initio investigation, thereby excluding complainants and their rights, and issues around the access to file. And more generally, including before the EDPB, there's been a widespread complaint that complainants have been sidelined in this process and not given a right to be heard. And so it's these kind of procedural divergences and procedural ambiguities that are taken up to some extent in the procedural regulation that others will discuss in a little bit more detail. The second big issue we mapped in this paper is about the lack of equality between national supervisory authorities in the cooperation procedure foreseen by the GDPR. So if you look at, for instance, the wording of the Advocate General in the Facebook Belgium case, he kind of considers the data protection authorities to be all on an equal footing, and that the lead authority, the one that kind of takes the lead role in transnational enforcement initiatives because of the place of main establishment of the controller. So in the vast majority of European cases, that is Ireland, or of the big European cases, that might be Ireland or Luxembourg. He considers that the lead authority is just a first among equals. But in reality, when you look at the way in which the cooperation and consistency mechanisms have played out, you can see that if you think of an investigation as proceeding in a couple of different steps, so one is the scoping of an initial inquiry, then the next step might be fact-finding, the next step would be a decision, and then the final step might be remedies or corrective measures, that when it comes to this first step, the scoping of the inquiry, and the last step, which is the imposition of corrective measures, that the lead supervisory authority has to date played a really outsized role. And of course, you know, as we see in things like the Twitter case, maybe even a better example would be the NOIB, the none of your business complaints around Meta's data processing operations. If a supervisory authority, in that instance the Irish one, ignores or fails to progress 2 out of the 3 grounds of complaint, and then gets a couple of years down the line in that investigative process, it can be too late then for the other European supervisory authorities to intervene and to say, we think you've scoped this too narrowly. And so I think, or we argued in the paper, that this lack of equality between supervisory authorities is generally problematic because, first of all, the GDPR was supposed to grant European residents equal rights. And in this way, the voices of some national authorities have been sidelined in a way that then negatively impacts on the residents of those states. So, and then the second point is that you have legitimacy issues because the more active national supervisory authorities are effectively neutered in this process, and you get a kind of a lowest common denominator approach to enforcement. So this is probably a picture that you're already quite familiar with. What does this new procedural regulation proposed by the Commission do? So I'm sure others will kind of say a lot more on this, but it tries to remedy some of these issues by, first of all, getting other supervisory authorities, so-called concerned supervisory authorities, involved in investigations at an earlier point in the investigative process. So now we see that the lead supervisory authority has to send a summary of key issues to the other relevant agencies before it kind of goes further in its investigation and essentially before it's too late. The second thing you see is that it has to now provide preliminary findings prior to a draft decision. So this is just another way to force cooperation amongst kind of otherwise incalcitrant kind of supervisory authorities who've been kind of failing to play nice with one another. So we're kind of adding more procedural obligations through this regulation to try to remedy this lack of equality between supervisory authorities. The bigger question, perhaps, is this kind of divergence between the agencies about what their role actually is as authorities tasked with data protection enforcement. So this is a quote from the Irish Data Protection Commissioner's 2021 report. And they note that while the volume of work being completed by the office is ever intensifying, what has remained elusive in 2021, we could say in 2024, is any kind of agreed standard by which to measure the impacts or success of a regulatory intervention in the form of the GDPR. So they're saying there, we don't know what kind of benchmark we should apply in order to see whether or not our work is effective. I mean, we could say, well, we know what the counterfactual looks like ineffective enforcement. But how would we know if the regime was actually successful? And here, as has already been kind of hinted at, we have a couple of key debates that remain outstanding. So one of them is whether or not supervisory authorities are required to actually deal with all complaints. I think that is now, to some extent, resolved by the Shufa judgment of the Court of Justice, where the court talks about the responsibility of each national supervisory authority to handle complaints to the extent appropriate. So I would say there is a legal obligation to handle all complaints. Perhaps others would disagree. But then the trickier question is, well, what does handling to the extent appropriate mean? And we see here that there is kind of wide divergence on this, and this goes to the question asked earlier, I think by Jim, about is it open to data protection authorities to engage in kind of responsive regulation or so-called responsive regulation, to escalate up a series of responses or the regulatory triangle, starting with kind of discussions with controllers in the case of violation, and then kind of gradually only arriving to administrative sanctions. And here, this is something, again, that the procedural regulation seems to address to some extent. If you look at Article 4, it talks about the factors that you need to take into consideration when assessing the extent appropriate to investigate a complaint. And so some of these factors are things like, is it a systemic and significant risk? And if so, then I guess you would need to investigate that complaint to its fullest. So that already gives us a very clear answer to some of the questions that have been dodged. But other things are about the need for a quick response for the individual, for example, or the severity of the potential harms. The other thing is that this regulation states that amicable settlement can be used, and I'm kind of paraphrasing here, but can be used essentially where the complainant agrees. So this means that not all complaints will need to kind of proceed to a decision point. You can engage in amicable settlement. So this could allow authorities to legitimately kind of pick off low-hanging fruit when it comes to enforcement. So we have had the regulation does bring some clarity on these issues. But I do think when we think about enforcement of the GDPR, for the rest of the panel as much as the audience, in some ways the procedural regulation is just trying to lock down some of those gaps that we have from the enforcement of existing mechanisms. But we do have kind of broader questions at play here. So, the big one to my mind is it desirable when we look at these extremely complex procedures where no one court or no one regulator can get a handle on the entirety of the process? Is it still desirable in this area to maintain the principle of national procedural autonomy for EU member states? So this is something that is, very controversial to try to harmonise EU administrative procedures. But when you look at the the opposite and what we're left dealing with, you might say, in some instances, it's better to cede a little bit of sovereignty than to be left kind of dealing with this mess. Another issue I think is quite important is that we see an almost total absence of regulators willing to actually target the business models of data controllers and to impose any kind of behavioural remedies. And this, I think, stems from counterintuitively, I think, if I looked at some of the comments by Helen Dixon or others, a perceived lack of legitimacy on their own part. They don't believe they have the legitimacy to do that because they're kind of technical regulators rather than rights enforcers, even though, you know, the GDPR was adopted with an overwhelmingly supported kind of democratic mandate in the Parliament and Council. But also maybe a risk of, you know, economic detriment and a bit of a kind of too big to fail attitude that the regulators are afraid to kind of step in or be too intrusive. And so I think these kind of go deeper than the procedural harmonisation regulation that we'll obviously touch upon again today. I'll leave it there.
Thank you very much, Orla. I think next we're going to have Luca. So Luca Tosoni from the Norwegian Data Protection Authority. He does not have slides, so you know what, we'll just leave Orla's last slide up because that seems really something interesting. Okay, Luca, thank you.
Thanks. So, thanks very much. It's a pleasure to participate in this panel, and I'm sure we'll have also a very interesting discussion afterwards. So I will try to bring the perspective of a regulator to the table, so that maybe, you know, that will contribute to an interesting follow-up, and we can use some of the time today to engage with each other's argument. It's a bit difficult to be here in my capacity today after what we heard in the previous panel, because it's difficult to justify what we do in a way. So I will try to bring some optimism or some of the good things I think that have been done in the past few years, and I will also try to highlight some of the challenges we have faced trying to enforce the GDPR. I think, first of all, it's good to remember that over the last 5 years, European DPAs altogether have imposed or have adopted around 1,000 final decision, final one-stop shop decisions, which is just the tip of the iceberg of all of the decisions adopted by European DPAs. This is because, as you know, the one-stop shop only applies to certain cases, mainly cases about multinational companies, you know, the Google, the Facebook, and the like, but not only, also smaller multinationals that have maybe 1 or 2 offices in different countries. But most of the enforcement so far is actually national level enforcement, which probably is something that many overlook or don't consider when they think about enforcement, and probably we from, let's say, the DPA community should be better at communicating also that kind of enforcement to also help with what is the perception of the current state of play in terms of GDPR enforcement. I think it's also good to flag that around 7,000 fines have been imposed over the last 5 years for a total amount of around or over 4 billion euros. And I think we can talk about maybe the quality of the enforcement, we can talk about the content of each of these decisions, but I would argue that these are not negligible numbers per se. So there has been enforcement, we can talk about the quality of it, but I think it's fair to say that the GDPR has been enforced over the last 5 years. And I think over the last couple of years, there has been an attempt by DPAs to really speed up and improve their cooperation, in particular within the one-stop shop system. You might recall the famous Vienna Declaration, where all European DPAs gather in Vienna to try and discuss exactly what we are discussing today, and try to find some solutions for the future, or some ways to improve enforcement and facilitate cooperation among them. And some of these, the decisions that were made in Vienna are now being implemented slowly but surely. I think it's also good to remember that most of the enforcement focus on the very key principles, the very key requirements of the GDPR. So it's true that the GDPR is complex, it comes with 99 articles. If this procedural regulation will be 99 plus 31 articles, but it's also, I think, good to remember that enforcement has also been quite focused on the core issues. Bertie App was talking about the general principle. We should go back to the core principles, and I think enforcement has been focusing on primarily, let's say, legal basis, the principles in Article 5, and data subject rights. So the core requirements have been the focus of enforcement so far. But we should also remember that up until now, I would say that enforcement has been, in my view, unfortunately, very much complaint driven. Enforcement until now has been the consequence of the kind of complaints, the very many complaints that DPAs have received so far. And given the current resource constraints that we are facing, DPAs had to follow a bit complainants in deciding what they wanted to focus on in terms of enforcement, also because of what Orla said regarding our duty to handle each and every complaint we received. While I think probably if we want to focus on the core issues that also have been highlighted during the course of today, probably DPAs need to free up some resources to maybe focus a little more on ex officio investigations, maybe also in cooperation and having a dialogue also with civil society, NGOs and stakeholders at large to identify what are really the pressing topics, the pressing issues. But I think we need more ex officio investigations and probably a bit less complaint-based investigations. Also because the GDPR has helped with data protection awareness around Europe. People are certainly more aware of their rights today than they were 5-10 years ago. But people tend to be aware of the basic things. People know that they have the right to access their data and receive a response within 30 days. They're not so much aware of data protection by design or by default. They're not very much aware of what the fairness principle entails. Probably we are also not very much aware of what that entails, but surely not data subjects, right? So if we want to focus on the core issues that a lot of the speakers have flagged today, I think we need to leave DPAs also a little more margin of maneuver to decide what to focus on based on transparent and previously agreed criteria also, because accountability is indeed important when we talk about enforcement. And I think maybe the procedural regulation will partially address this, but I'm not sure we are, the solution has been found in this respect so far. But to free up resources and to have better enforcement in place, I think we need more resources. Most DPAs in Europe have 60 or less staff members. Some have less than 15. So we're very envious of the ICO and the 1,000 employees they managed to hire and use for enforcement purposes. But we at the Norwegian DPA, for example, we are less than 70 people, sometimes working on these very big cases, which are very time demanding. For example, on the Meta case, which is probably one of the most followed cases we are currently working on, it's roughly 10 people working on that case. So it's not so many after all when you think about the challenges that working on such a case entails. So resources is certainly key. Also, as has been mentioned previously today, the regulatory landscape is getting more complex, both in terms of interplay between data protection law and other legal regimes, but also in terms of what will be the future role of DPAs, also in terms of enforcement under other legal regimes. Most likely, some of us will get extra responsibilities, but so far we haven't seen a commitment also to increase the resources in the same pace or in accordance with the new responsibilities we will get. And most likely, in typical European style, there will be divergences across Europe. So in some countries, the national DPA will be in charge of the AI Act. In some others, it will not. And this will, of course, make cooperation and enforcement across the continent more complex than it is currently today. Also because we already have an experience with this, for example, when it comes to the interplay between e-privacy rules, so cookie, for example, requirements, and data protection. In some countries like Norway, for example, the jurisdiction of the enforcement competence is split, and even in rather basic cases regarding cookie banners, it becomes quite complex where several authorities need to be consulted and involved in the investigation. Also, I think it's important to ensure consistent application or consistent enforcement beyond the one-stop shop. The procedural regulation that the Commission has proposed only focuses on improving the one-stop shop, which is a decent system which allows authorities to talk to each other and try to find a common approach to a certain case. But as I explained previously, most of the enforcement today actually takes place outside the one-stop shop, and that is not small enforcement. It's enforcement about big state authority, big public authorities, also big multinationals which do not have any offices or establishment in the EU. We had a case, for example, against Grindr in Norway. That is a case that didn't go through the one-stop shop system. It was a national case, but a very big case, also a very demanding one. And we need tools, we need procedures to make sure that we are also consistent when it comes to this kind of cases. And in terms of solutions or what can we do to improve the current state of play, I would say that on top of having probably more resources, but that was clear probably from my previous remarks, we need to be better at prioritizing and deciding what cases go first and what cases can be left a little bit behind or can wait in line because they are maybe less important or concern issues that are less systematic and affect a data subject to a lesser extent. And I think until today, how we prioritize cases is more of a craft, more of an art, more of an art than a craft. So we need also to be a little more systematic about how we decide what should be prioritized and try to be more coordinated at European level. I think there was already commitment in Vienna to try and share that enforcement strategies among European authorities, but I think we can get better at that. And I think we also need to dare using all of the instruments that the GDPR provides, all of the enforcement instruments that we have under the GDPR. I think we in Norway were probably the first to successfully use Article 66.1, so the urgency procedure. Probably that is also something to be explored more often, and I think we have seen other authorities following in our footsteps in some cases. But also, we should try maybe make more use of Article 64.2, meaning requesting consistency opinions from the board. And this is a tool that can be used earlier in an investigation instead of going all the way to a dispute resolution when the damage is done in a way. So if we would make more use of this kind of opinions, as we are trying to, we could maybe find an agreement and a common European approach at an early stage instead of kind of disagreeing at the end of the process where things become more complicated. I think Orla has already explained very well what are the key elements of this new procedural regulation, so I don't need to summarize that. But what I can say is that I think that the idea of trying to iron out the differences that we see currently in terms of procedural requirements across the EU is a good idea. So I think we are very supportive of having a regulation trying to do that. But I think there are still probably some things to be fixed in the proposal of the Commission. One core element which I think requires some adjustments is probably to try and clarify when the procedural rules apply. Because sometimes I think we take for granted, or we jump too quickly to the conclusion that the one-stop shop mechanism applies, but we need to remember that the one-stop shop mechanism only applies when cross-border processing is at stake, which, I mean, having made that assessment many times, it's often not that obvious, and the focus should be on the processing rather than on the controller per se. So it's a rather complex assessment to be made, and if the regulation could facilitate that assessment, that would be certainly great. I think it would be also important to have harmonization concerning admissibility requirements and be quite exhaustive with that. Very often we spend time at the beginning of an investigation also trying to understand whether what we have received is first and foremost a complaint, which is a term that is not defined in the regulation. So sometimes it's not easy to really understand if we should treat it as a complaint or not. And then once we have concluded that we have received a complaint, is that complaint admissible or not? And here's where national rules come into play and can lead to different conclusions. And I think if the regulation could provide a set of criteria that would apply in the same way across the EU or the EEA, I should say, coming from Norway, that would be also very much appreciated. And finally, I think you also pointed to the issue of access to the file and confidentiality. I mean, for us in Norway, this is a pretty sensitive topic or issue, given that access to documents is a constitutional right in Norway. So restricting that access considerably would be, at least for us, quite problematic from a constitutional point of view. And I'm pretty sure that similar problems can be also raised in other countries. So I think we need to be pretty careful when we try to restrict access to the file, being that from the parties in the case or from the general public. I think I would leave it there. We probably have already quite a bit to discuss, but I'm sure, Johnny, you will have quite a bit to add, and after your intervention, we'll have even more to consider.
Thank you, Luca. Next, we're going to have Johnny Rand from the Irish Council for Civil Liberties. Thank you very much.
Amazing. So Jennifer and David, thank you very much for bringing me back to Cambridge University for the first time since my doctoral conferral. It's a strange thing being back in a place where different corners, different sounds and sights remind you of relationships that have gone and a different stage in your life. When I was here, I had a wonderful supervisor in a monstrous building right next to us there, the history department. I wasn't studying in the history department, but Professor Chris Andrew is a historian. And in David's incredibly vague, rough note about what we should speak on, which is great guidance. It's nice not to be given good guidance and clear guidance. This is good. He said he wanted a little bit of discussion about where we are, how we got here, and, you know, where we're going, right? What's next with enforcement. Now, I wonder, hitting the wrong button, I wonder if we were to go back in a time machine with my history department hat on, I'd like us together to go on a little journey back to 1964. I want to introduce you to an engineer, because engineers can tell us an awful lot about data. Does anyone know this guy? Okay, this is Paul Baran at the Rand Corporation. Now, Baran was working on a set of very big problems. One of his big motives was when he was, now this is not from 1964, but we're going to look at 3 documents. One of the big problems that led him to produce this series of documents called On Distributed Communication was that when he was writing, this is Sarabama, I think this was from 1962, we had 2 problems. Nuclear weapons were getting more powerful, they were getting more accurate, but also they could be launched quicker because both sides were moving from liquid fuel to solid state. So you could quickly launch a nuke. And what Baran says in On Distributed Communication is that when you have a, whoa, this is what happens when you move from Keynote to PowerPoint. When you have a highly centralized network for comms, for communications, it is obviously vulnerable to the destruction of a single central node. In other words, if they hit us, they'll know that we won't be able to communicate with our nuclear weapons to hit them back. And these papers were made public so that both sides would have access to this idea. And it's in this document that you get these very, very famous drawings. So this is the network system as Baran found it. Every bit of control is at the center. And this is what it gives us. Very, very famous diagrams. The network, right? Now, he's thinking about how it might work and he's thinking about digital technologies, and he is not the one who implements it. When he takes it to the US Air Force, they think he's talking crazy talk. So he's not the one who's involved in the ARPANET and so on, but he's an important key player at the beginning. And his diagram of distributed communications, it looks like social media, it looks like modern political campaigning. It's a pervasive thing in our lives. Now, he wrote a series of papers. This is the next one, where he says, look, we are going to have, this is about the engineer's ethical duty. We are moving to a point where much of modern life will rely on the small decisions that other engineers take. And those small decisions may not be informed or guided necessarily by the long view. It's this idea of code. Code is law, code is something else, but code is significant. And he also says there will be engineers who don't give a damn about ethics. And he has some very choice language for those people. He calls them the whores of industry, just in case the slides aren't kept. That's Paul Baran, the person who gave us our pattern of life today, as we know it online. He saw some of the problems we were going to be facing. Now, in 1967, he writes, the coming computer utility laissez-faire, licensing or regulation. And in this document, he says, information about us is going to be stored elsewhere. He keeps going. These papers are incredible. He talks about using your computer to access shopping. He talks about cloud storage. It's all there. you put it together with Douglas Engelbart, and you kind of get where we are now. Now, in this paper, he's saying, look, we cannot have a laissez-faire approach here. We need rules. This needs to be policed, one way or another. Right? And he says these rules need to do a few things. They need to protect people. They need to encourage competition. And they need to not be a regulatory nuisance. Right? So that's Buran. Now, let's leave the slides for a moment. Now, Buran saw about 60 years ago that we needed rules that would protect us all. We need rules that will also allow competition. And we need these rules not to be a nuisance. So we don't have the first two. We've got very little protection. And we do have the third. We've ended up at a point where we have a nuisance for the small players and we have a gift for the big ones. And we've talked about it a bit, but let's look at maybe some of the reasons why and what the cause is. So these are grabbed last night from our 2023 report I think it's called GDPR's Crisis Moment. It says exactly what it means in the cover. You'll get it from myccl.com. And I haven't looked at them since we published them. So some of these companies may have moved around. But last time I checked, this is where they were, I think, claiming their main establishments were. Amazon, Luxembourg, and then the other top five, the other four of the top five in Ireland. Now, so again, a caveat, we haven't updated these figures since we published them. But going to the available data that we can find, solely looking at final cross-border decisions that resulted in any sanction, excluding all of the others. And the first 4.5 years of the GDPR, this is the makeup. Now, I'll explain it to you. The first thing to note is nearly everything's a reprimand. 2/3 were reprimands. I've been in industry. Reprimands are okay. You can keep them coming. That's fine. Thanks. Give us more. Reprimands. Okay, only 50 of them contained compliance orders. Now, bit of context. I added up all of the budgets of all the Lander DPAs, all the EEA national DPAs with Alan Toner when we wrote this report. I think the budget was something like 320 million. I can't remember. You can check the figure. That's the enforcement budget. That's the costs, right, to the taxpayer. 50 compliance orders. It's a problem. I'm suggesting it's a problem. Here's as of the 9th of May, 2023, so looking at around about 5 years of data, this is the number of final decisions following an investigation. And then if you factor in amicable resolutions, it looks a bit strange. And actually, this would now be far more skewed. So for ye academics in the audience, be very happy to work on this with you. We need to update these figures, check them again, make sure they're up to date with the latest. But I guarantee you that's going to look even stranger. So if you're focusing on big tech, the really big players, the VLOPs, the gatekeepers, however you want to define them, the people who will lead us to dystopia, if you're focusing on them, the ability for them to continue their internal data free-for-alls is clearly a problem for any nascent competitors that are going to produce anything better. Right? We know this. The ability for them to continue to process data the way they're processing it for recommender systems is clearly a problem for our children. It's a problem for information in our society, for disinfo. And what's happening in ad tech is clearly a problem for the business model of journalism. But we've also got this situation where the small player has to live in fear of this enforcement hazard hanging over them, and the big player actually seems to benefit from it as an advantage. Whereas in truth, if you had enforcement against the big players who provide the systems that everyone else uses, you would probably have much more compliance across the entire system. So let me tell you another story. I'm not unique in this. In the months leading up to the GDPR, I received a cascade of spam saying from multiple parties, "Hello, Mr. Ryan, we'd like you to reconsent." or consent for the first time. If you cast your mind back in late 2017, early 2018, right, there were you were getting flooded with these emails looking for your consent. Now, when we talk about robust, if necessary, adversarial, proactive enforcement, not waiting for complaints, not having to be guided to the well, right? When we talk about that, what we mean is just one of the authorities in Europe who would have had the power to do this under existing law before the GDPR could have gone to one of those parties who sent a spam email. And I'm sure they did. I'm sure one or two did, but had the following conversation. Who told you to send this spam? And the answer would have been, oh, I heard that from the system, like MailChimp, for example, that provides my mail service. And then that authority would have ignored the bottom level, right, the small SME, gone up to MailChimp and said, we're so curious, we'd like to see your guidance to your hundreds of thousands of SME customers, maybe 50,000 of them in Europe, maybe 100,000, who knows? And they could have corrected it. They could have corrected it at the top. And what we haven't seen is this enforcement from the top. And instead, we're seeing an absence of enforcement in data protection against the big players. And that creates big problems, not just for all of us, but for the adjacent regulators. In this jurisdiction, Comreg, that's Ireland, Ofcom and CMA are dealing with problems that are left in the vacuum where the ICO should be. We would probably, I have thought, not need most of the Digital Markets Act if we had actually applied the GDPR. And I would say the same for much of the DSA. Right? So what we have instead in Europe is this system where the last European Commission produces the GDPR. It says to the world, this is the big game. We mean it. Brussels effect. We really mean it. And they sprinkle it into the water of the regulatory tank, and it slowly, slowly silts down to the bottom. The new Commission comes in. They totally ignore the GDPR. And then they start sprinkling on new sedimentary layers of regulation. Not only does that mean the law does not get applied, it means that Europe's global role changes. I do remember having colleagues in the US, when I was in industry, ask me from other companies, do the Europeans mean business about this regulation? And naively I said, yes, this time I think they mean it. Europe convinced the world that it meant it. And when it turns out that it didn't, you can see what happened in India. India had a really nice clone of the GDPR, very, very, particularly nice, dumped. Took a few years, they didn't enact, dumped. There's no reason to enforce any of this stuff if Europe's not going to do it. So let me suggest that, and I'm going to wrap up in a moment, that we have two problems. We don't have one problem when it comes to enforcement, we have two. So there's national, and there's Ireland, which the DPC now has new leadership. We may be about to see a revolution. We will be very, very interested if that happens. We'll assist them all that we can. But let's see what happens. And then you've Luxembourg. So that's the national level. But there's a second level, and that is the Commission. The European Commission, as guarantor of the treaties, has the task of making sure that member states apply the law. It doesn't matter that these authorities are independent. If your courts were behaving in a particularly offensive way to European law, the European Commission would be empowered to intervene. Now the question is, would it win the case or not? That's a different question. But instead of intervening, they are covering. That's where we are. So we've got two problems. It's at national and it's at the Commission level. And so the question is, where do we go from here, right? Do we have solutions that get us back to Paul Baran's example? Right now, the European project of data protection, which could, I remember lobbying in Washington, I remember lobbying and saying, this law is based on your FIPS. These are American ideas, take them home. I remember saying that. And they said, you want us to cover our internet with this crazy red tape that you've got going, with this nanny state stuff, this over-compliance. And they're still saying it as of 4 days ago. And they're right. Because the enforcers didn't step up, just like with MailChimp and the mail spam, and say this consent spam is also illegal. And we're still litigating it. And we will be for another half year at the Brussels Market Court. So how do we get to a point where we can not only apply this law in some sensible way on the big players, cascade it down through the rest of the economy and the society, but also have this Brussels effect actually have an effect, not scare off these people, but bring them along with us in some useful way? I think there's 3 reasons, not for optimism, but 3 things maybe to look at. We have had totally ineffective measurement and supervision by the European Commission. Now, there was a long process that we went through at the EU Ombudsman, and out of that process, the European Commission committed to monitor all large-scale investigations across the Union 6 times a year to get updates. Now, that doesn't really cut it, because, of course, you could have things that should be should be a large-scale investigation, but went the amicable resolution route, which I suspect is a large percentage. It also doesn't cut it because it doesn't look at the 5 years of cases we've had to now, but it's something. So monitoring may be changing. The second thing is, we may see a change with the new commission when it comes in October. The current team at DG Just, those people may move around. There may be that may have a positive effect on this. And the third thing that I think is particularly interesting is the ability to directly litigate as complainants has been maybe the saving grace here to some extent. And collective redress means that you can take cases that are going to be consequential across the Union. So as we look at the next generation of problems, workplace surveillance, moving away from ad tech, when we resolve those things, what are the next generation things? I think the focus would probably be on collective redress if these other things continue to fail. Thank you. I look forward to the discussion.
Thank you very much. Up next, we have our final speaker of the day. Last but not least, one of these is going to be yours. Here we go. Gloria is going to tell us about her perspective on reforming data protection. Thank you.
Thank you very much. I'm very, very happy to be here. I know I am the last speaker. It is difficult. I'm the last speaker of the last panel of the last day of a long week. It has been a long week for me. Maybe it has been a long week for you too, but we can make it. Just 10 minutes more and we'll relax. But I was asked to talk, so I will talk, and I will talk about 2 subjects. So the first question is, what do you think about the enforcement of data protection in general? And then more specifically discuss the new proposal for the new regulation. I will try to cover the 2 aspects, which are related, but perhaps not that directly. So the first question is, what do you think in general about the enforcement of the GDPR? And I've been thinking about this also because it's not very important, but I am a member of one of these committees that the European Commission has, that we give advice to the Commission. Now, the European Commission is about to produce this, and Orla was there for a little while when it was still possible. So they have to produce this report about the 6 years of application of the GDPR. So they were asking, is this satisfactory, yes or no? So I tried to come up with an objective answer. How to actually evaluate this? This was the question also before. How to actually know if this has been a success or a failure? And I thought, well, maybe I don't know, but I can try to read how did the Commission itself think at the beginning when they proposed the GDPR, how are we going to evaluate if it works? And I saw that actually one of the elements was the number of complaints submitted by data subjects. It doesn't say we want plenty of complaints, but that's how I read it, that they thought when they said we were going to empower data subjects, we're going to make sure that they can use their rights, we want them to actually just complain more. And we will quantify the number of complaints and it will be much better. So there are a couple of documents from this already 12 years ago, saying we really want to make sure that data subjects lodge complaints and that they are effectively followed up. So then I thought, well, maybe now we have somewhere the number of complaints, but actually, in case you don't know this, there are no statistics about the number of complaints that data protection authorities receive in their annual reports. They report about something in ways that actually are not compatible. You cannot really count exactly how many complaints were lodged. It is very, very annoying. And just also to criticize a little bit the European Commission, when I asked them, what about this? They said, was not us, this was other people at the European Commission, and actually we prefer that there are no numbers about the complaints because people will misinterpret them. So, okay, so no numbers about the complaints. So then how do we know if this is a success or not? What is the benchmark that we can use to know if the GDPR is working? So then I thought, well, how do we do this in academia? We try to compare. So with what can we compare? I think now we are very lucky. We have plenty of things to compare with. And you have heard all these acronyms already many times today. Had you ever seen a beautiful diagram like this one? Never, never. So here it is. This is what has happened in the last 4 years. If you were not paying attention, it will be hard when you start reading everything, because it is really hard to really process all this information. But this is what we have. We have plenty of laws there that are somehow related. You will say the GDPR has been ignored. I think it has never been ignored. It has been used as inspiration, as saying, well, things that did not work in the GDPR, we are going to improve them. Some things are going to work better. So then I thought, I had this idea, maybe we can compare with that. And then actually came to the conclusion that actually the GDPR is also somehow living as a zombie, I don't know, or as a real thing, also in many of these instruments. So basically, I don't know what are your feelings. I wanted to share my feelings. Thinking about how the data protection relates to all this, it was first, sometimes it is still a feeling of fear. It is sometimes a feeling of jealousy, and it is also a feeling of hope that I will try to now explain what is this. And my feelings, not only my feelings are important, but really dealing with all this new picture and this tsunami and all these things, it's a challenge for data protection people, for the DPOs. The EDPB did this very wide survey about what is happening with the DPOs, and the DPOs are struggling. They are confronted daily with this question, how do you deal with this problem, which is not a GDPR problem, it's a Data Act problem. And bad news, actually, they also discovered that actually DPOs don't have the time to follow, because actually nobody has the time to follow, but we have to. So I was saying, when I look at the GDPR and I look at the broader picture, sometimes I have this feeling of fear. I think we are sometimes requested to do these kind of things, just because I know that you're critical people and you like to these conceptual challenges. This is one of the things that we have to accept when we read all this. We read the GDPR, we have a definition of personal data. Did you realize that actually the Data Act and the Data Governance Act have their own definition of data? That does not really make a lot of intuitive sense, because they say, well, data is a digital representation of something, while for us, data is any information. So it is tricky. You really have to be prepared and calm and paying attention. There are many things. I will not tell you all the things that I think are scary. There is this regular sort of misuse of consent or strange perceptions of consent in the Data Governance Act. There's an obligation for public sector bodies to actually help anybody who wants to use data that they cannot use, to help them see the consent of the data subject that is supposed to be free. So, no, I remember, no, they didn't remember, but well, that's the fear part. So then sometimes I actually am jealous. I'm jealous because I think so many things that we have been sort of dreaming of, and we were told it's not possible or it's wrong, they happen in these other instruments. What we have been discussing many times, so this idea of collective action through remedies, Article 80, but there is a whole community of people thinking maybe also rights, access rights or data subject rights can be used in synchronized ways. You could help data subjects to use their rights. Also, for instance, with technological means, automation of rights. Isn't this a beautiful idea? Not a beautiful idea. According to the data protection authorities, they are saying, ooh, data subject rights, this has to be, you have to submit a request personally yourself. If we receive requests through a portal, it might be spam, it might be a robot that is misusing the GDPR. We are very afraid of everything. So just in case controllers receive this kind of strange request from a third party, we consider actually they can also ignore the third party and look for the data subject. It is very like saying, no, you should not really believe this kind of request. You look at the Data Governance Act, yes. Third parties submitting requests, that's great. Let's support this. And actually, the Data Governance Act creates these data intermediaries and says some of these intermediaries, they will just be there to actually enable the exercise of data subject rights. And we believe in them, yes, and actually they say we will do everything we can to support them. Now, of course, what they can do is not much, so they say we support them by allowing them to use this logo. So, okay. Now, is this going to really help us? I don't know, but they try, they submit colors. They say, of course, it will only be when you use your rights to actually enable the sharing of personal data. So there is a little catch. It's not that they will help you get help to actually just erase your data. That will not work. But then many things are happening. So let's keep this faith. It could be that actually maybe if things are possible, they are also possible for data protection. And when I have hope, I think that's the important part. We can also criticize and say, well, the DSA is different, but you know, probably that we learned or somebody learned from the limitations of the enforcement in the GDPR, and they said, well, we will do things differently in the DSA and in the DMA. So they are doing things differently, but the good news is that some of the things they're doing this for the GDPR. It is very much for the GDPR like this. So now we have the European Commission enforcer of the DSA, and they are actually trying to enforce this provision, which is about profiling and the use of sensitive data. When you look at the provision that they are enforcing, it's the GDPR, the GDPR. So what are they doing? They are doing basically the work of Luca, so he can actually focus on his priorities. I don't know. They are doing a lot of enforcement of the GDPR in some way. And I think this is good. I'm saying we have this problem. Are we focusing too much on the GDPR? Well, in a way, yes. In a way, no. We are doing many, many things. Now, there was this interesting comment this morning. Enforcement is not a sprint. Maybe now the Commission is in this sprint and they will face a wall and things will be complicated. But now they are in this high confidence. Let's send letters to everyone. They do many things. And there are many interesting things also, for instance, in the DMA, this, in case you have not been following, now there is these audit obligations, which are also about the profiling of consumers through the DMA, and it is all about the GDPR, a lot of things about the GDPR. So I'm happy the GDPR might be limited, but I don't think the others are in competition or doing, actually they are somehow compensating, and this is good. I think this was all for my assessment of the general enforcement situation. And then I wanted to move to specifically the new proposal regulation. But for introduce this, it has been introduced. I will give you my summary of what happened exactly, because I'm not sure everybody has been following. Why did the European Commission in July submit a proposal for a regulation? The story is really about these complaints that people know that enforcement is limited. We look at data protection authorities and what do the data protection authorities say? Whenever you look at them, what do they say? We don't have money. Money. They say money. Money, no enforcement. And so they have been saying this for a long, long time, before the GDPR, when the GDPR was there a lot of time. So the European Commission has been trying to follow. So at some point, some DPAs appear to have money. So then they said, we have the money, but we cannot find the right people. And then they came up with other arguments. And at some point, somebody came with this argument. Actually, now we have the money, but there are things in our national laws, administrative procedural laws, that it's just impossible for us to do the work. It is very strange as a legal argument when you look at this from the European perspective. Privacy of European law, like is there something in your member state that doesn't allow you to apply the GDPR? Ignore it. It is magic. It is like this. You say, no. It is, we will have a wish list of exactly the problems that we have, and really have read this wish list. When you look at the wish list, half of the things, the problems that they have, they can solve them just by talking to each other. And that should be the role of the EDPB, that they solve the problems that data protection authorities have. And in my view, the European Commission should have told them, okay, you have many problems, but it is your role to solve them. They didn't. They ignored my advice. They did. They said, okay, you have problems, we will help you solving them. So we proposed this regulation. Why did the Commission accept to do this? I think because they also saw the opportunity to, by the way, by solving your problems, we will also solve them in the way that we want to solve them. So that's the opportunity. But they came up with this proposal for a regulation. There are good things in it, and I really hope that after that, at least, yes, we delete another possible argument from DPAs to say, well, we don't have the money, now they have the money. There are strange things in national law. Well, now there are no more strange things in national law because it has been harmonized. That's the hope. Now, of all the issues around this regulation, there is something that for me is very, very important to discuss, and this has been mentioned but not really discussed, and that's amicable settlement. So really, that's the last point that I want to discuss. Why do I think it's so important to discuss amicable settlements? Can anyone be against amicable settlements? Well, you can if they are misunderstood, misused, and I think they really are. So there are some guidelines of the EDPB on amicable settlements. They are public because that was not the plan of the EDPB. It was to have internal documents. Actually, the EDPB systematically thought before, some time ago, that they could discuss anything related to complaints and procedures internally, that it was not a problem for the planet, that they could just have internal discussions, thanks basically to Johnny Ryan, but also others. Some pressure was put there. They actually saw that people wanted to see these documents, and eventually they said, we adopted this initially as an internal document. It has now become a guideline, and it is a guideline, and you can read it. And when you read it, and I hope you will, you see that they discuss amicable settlements. But at some point, the EDPB thought it was good to have some guidelines saying what's the European approach to amicable settlements, because the GDPR doesn't really clarify this. And in this discussion of amicable settlements, they just say, for us, amicable settlements is an alternative dispute resolution mechanism. An alternative dispute resolution mechanism, where is that in the GDPR? It is not in the GDPR. In the GDPR, you either go to the courts or you lodge a complaint. And you lodge a complaint is a very specific thing. Other instruments say, we will put in place a system of alternative dispute resolution, but not the GDPR. So in their head, it's normal that when you lodge a complaint, instead of going through the procedure of a complaint, you are sent to an alternative reality, alternative dispute resolution that nobody foresaw. So that, I think it's a problem. And because there is this broader conceptual problem, I am personally worried. There is a general problem, a conceptual level, but also in the practice of the way in which these amicable settlements are being used now, which is just contrary to the letter of the GDPR. And for me, what is worrying, nobody seems to care at the EDPB. Lucas said, yes, they care, but I don't know. So what is this about? This is basically the one-stop shop. The graphic is very ugly because I did this for the European Commission. They don't pay me for this. But it's ugly. So what do you do? What's the one-stop shop? You lodge a complaint, it goes to the local data protection authority, and it could be that it's discussed and that actually the controller is sanctioned, but it could be that the decision, the final decision is that the complaint is rejected. And in those cases, the GDPR says, well, if it's going to be rejected, it will be the initial DPA that tells you this, so you can actually contest this decision in the member state. So you don't have to actually fly to another member state just because the one-stop shop applies. That's the logic of the GDPR. It's a compromise between helping data controllers and helping data subjects. Now, there is a reference to amicable settlements in a recital of the GDPR, and I really think that their idea and the understanding of some people at the Commission was that actually, because the one-stop shop is so complicated and it can take a lot of time, before you even send a complaint to this system, consider if it's a simple case that actually just trying to have this amicable settlement before you send this complaint to Ireland. Basically, in a nutshell, that was the idea between the lines of the GDPR. Now, this is not at all what is happening. What is happening is that people lodge complaints with their national data protection authorities in Spain, in Belgium, in many places. This goes to Ireland, and then Ireland says, it looks like this, we could solve this through an amicable settlement, because actually we are the only member state that has these international laws, but we like to apply this, so it's an amicable settlement. We will find a solution. This basically means that they send a letter to the controller, then they inform the data subject that the thing has been settled. And then in this letter, they say, if you disagree with this, you can go to court. Which court? The Irish court. Funny, but not for the data subject, because they have to fly. And this is for me, a mistake, because this is equivalent to dismissing the complaint. So there are cases of this. There is a transparency register of the EDPB where you can find some examples of this. And just to show you that it's true, the last one that they published is from 2022 because they have their own rhythm. They are very busy. So they said, well, we inform you that we have closed your file. We didn't dismiss or reject, but we did close the file, and you can go to the Irish High Court. So I think this is just wrong, contrary to the GDPR, and this is published and nobody cares, nobody does anything. And I think the procedural, what we will have, maybe they will insist that this is not possible, and hopefully it will be changed. I don't have a lot of hope now. So the Commission was more or less perhaps informed. The European Parliament has already adopted its position in the first reading. Many good things in that position, not about this, because they also seem to have a very strange idea. They think that actually amicable settlement is not something that the Irish DPA will put in place, but this is really a real amicable settlement that the controller calls the data subject, hey, and then they go and they inform the supervisory authority. So how can the result of this discussion take us anywhere? I don't know. I really hope that people will understand that we have to have an open discussion. What do we mean with an amicable settlement, and does this make sense? So yes, in the meantime, really that's the final slide. While we try to somehow mesh things with the amicable settlement, I think I understand the purpose of getting rid easily of some complaints. The Court of Justice in Luxembourg is more and more clear that actually a complaint has to be a complaint, that actually it's a decision that can be reviewed, and that the message that we have from Luxembourg is that you really have to have a meaningful procedure. There's also a very interesting pending case about the possible abuse of rights. This is somebody, I really don't know who, in Austria, who lodged 70 complaints with the Austrian Data Protection Authority. And the question is this excessive? Is this abuse? That will be an interesting one. I hope we will get more clarity about the right to lodge a complaint. And that's it. Thank you.